Good afternoon, Allison Scobrick here, Consolidated Planning Group. We are delighted that you have joined us today. We are really happy to be back with the week's law firm, Rachel Dickison. She is an attorney and she's going to be talking to us today about the Special Needs Trust. So we're going to take a deep dive into that. Many of you have submitted questions ahead of this webinar. We do have those questions and we're going to get to as many questions as we can during the time that we have together today. Today we're going for an hour. We are in webinar mode, which means that you can't see us or you can't you can't turn your video on or your microphone on, but you can, the chat box is open. You can actually put additional questions in the chat box. If you sent your questions in, we've got them. You don't have to put them back in the chat box. We will go over those for sure. Today's webinar is being recorded, and when you register for the CPG webinars that ask you a question, if you would like the slides following the webinar, if you say yes, you're going to get an email with the slides and a link to the recording. If you say no, you're not going to get any of that. So I think almost every webinar somebody asks if we're recording, if they can have a copy of the slides. I always like to mention yes, we like to share a copy of the slides so that way you don't have to take notes on everything that you hear and you can go back and refer to it on what you heard. So Consolidated Planning Group, we are a holistic special needs planning firm. We have over 30 years of experience, nationally certified as Social Security advisors, members of the Special Needs Planning Academy, chartered special needs consultants. Our whole firm is nuanced and planning for special needs. I come to you as a parent to four, three with disabilities, adults who have transitioned into adulthood. And so what I would say is here at CPG, we eat, sleep, and breathe this. This is who we are and exactly what we do. We partner with families just like yours who have a loved one with a disability, and it could be any age. Maybe you have a small child, maybe you're here because you have a sibling that you're caring for, and there could be any number of other combinations out there, but you're definitely in the right place. We put protection plans in place. We do a lot of lifetime care planning, transition planning. We help establish ABLE accounts, and we do a lot of advocacy by way of our webinars. Our webinars and our YouTube channel were born really out of my own frustration as a parent on why is everything that we do so hard? Why is it so difficult? Why do we always feel like we're going to say one wrong thing or do one wrong thing and we're going to mess everything up? And so I understand that a lot of parents feel overwhelmed with all of the stuff they're supposed to do, especially if your child is getting close to or has already turned 18. And so these webinars are out there. The Consolidated Planning Group YouTube channel has over 500 webinars on planning for special needs. If you can think of a topic, it's probably out there. And they're out there to help you on your journey and help you feel empowered as opposed to defeated on the steps that you need to take to be successful. So we are big fans of developing a future care plan now. We're fans of not waiting for the crisis to happen or the death or incapacity to happen. And really thinking about those things and being intentional on what your planning options are. And I think it's important to note that we may not always feel as great as you feel right now. One day you might be 85 years old and you might not be able to provide the caregiving services that you once did. So thinking about that while we're of sound mind and body is the best steps. When it comes to planning for special needs, some of the things that we think about is considering post-high school and educational and vocational options. We do a lot of webinars on that topic, that very topic, and I know that you guys are partnering with your schools in the transition programs there as well. We suggest that you start touring transition programs, partial care, full care, residential communities, because some of the waiting lists can be quite long. And so you don't want to get to a point where you have to have it and there's a 5-year waiting list. We like the idea of going ahead and getting yourself on these lists and having the right to say no as opposed to needing to say yes and there's no availability. And so when it comes to planning for special needs, we're fans of making careful considerations before naming siblings as a future caregiver. Sometimes we see siblings as a successor trustee on a special needs trust. But with a careful plan, we've got plans in place and proper funding in place to fund care for your loved one. And so that way that sibling can stay in that loving relationship and not a relationship of, kind of obligation. And I always like to think of, like, as far as siblings, a lot of times siblings are of similar ages. Sometimes we have big age gaps, but a lot of times they're of similar ages. And if they were saddled up with being the future caregiver, it may affect relationships, their jobs. They may be planning their own families and things like that. So plan early and update your plan accordingly. So Rachel, today, I know you're going to be going over the top 10 questions about special needs trust, and we've got some writing questions, and I know that you have those, but tell us a little bit about yourself and the Weeks Law Firm, and I'm going to have you take it away. Thank you again for being back with us. It's always a pleasure to partner with the Weeks Law Firm.
Wonderful. Thank you so much for having me. We always love coming. So I am an estate planning attorney, special needs planning attorney. I also do guardianship and probate, and we're located in Plano. So I specialize more in the Dallas, Fort Worth area, but we're here. We primarily do special needs planning. So today we're going to give you an overview of a lot of different topics. There's in-depth webinars on a lot of these different topics, but we're just trying to give you an overview of what everything looks like. Next slide, please. So the best place to start when you're thinking about special needs trust is what government benefits your child is eligible for or is currently receiving. So the most common government programs that your child may be on after they turn 18 is SSI, or Supplemental Security Income. That is $967 per month for generally food and shelter. Now it's more for shelter, and I'll get to why in just a minute. Then we also have Medicare, which is healthcare services, and Medicaid waiver programs that provide additional services beyond traditional Medicaid, including attendant care, respite care, therapy, residential, and medical care supplies. Next slide, please. So these programs, they all have their own eligibility requirements. Generally for SSI and Medicaid, you have to have a disability determination from the Social Security Administration. You have to have low income and limited resources. With the Medicaid waivers, they provide exceptions and they have different requirements from these. So each thing is going to be a little bit different and depending on which program you're applying for.
And I just want to do a side note here. We have entire webinars on government benefits, SSI, Medicaid, Medicare, SSDI, childhood disability benefits. Those are all going to live on the YouTube channel. It's Government Benefits 101. We also have entire webinars on Medicaid waivers, what the different waivers are and the various requirements. For anybody that is attending out of state, Medicaid waivers are state specific. So your state may be different than our state of what is offered. There's two things that I want people to know that are attending here from Texas. I know a lot of you already know this, but the Medicaid waivers in Texas have a very long waiting list, upwards of 20 years. They quote 17 to 20 years. So there is a very long waiting list for most of them, not all of them. There are a few, exceptions to that. And then the other thing that I want to mention is in the state of Texas, as it stands right now, applications for SSI and SSDI are taking over a year to process, which is shocking and it is not great. And I think we're kind of dead last in the United States as far as processing them. But they are aware and they are working hard and they have started pushing some of the workload out to other states that are not as busy. So I just want to set proper expectations for that. So if you have recently applied for SSI, there's no reason to think that you're going to be approved anytime soon. It's a slow process, so don't count on that money coming in probably for at least a year. I think it's wise to plan that way.
Okay, so generally I mentioned low income and limited resources. Low income generally is defined for Social Security, or excuse me, for Supplemental Security Income or SSI as less than $1,620 per year and less than $2,000 for Medicaid eligibility. Now, income is considered to be shelter, cash, and then any asset that can be converted into shelter or to cash. Now, when you have income, whenever that child is under the age of 18, the parent's income is deemed to them. What this means is that your income as a parent is considered to be their income. Once they reach age 18, they're considered to be their own household, and it's these income restrictions for them. Now, if you have $1 of SSI, you will be eligible for Medicaid in Texas. So that's just one background thing to think about. Next slide, please. Now, in addition to what income that I just talked about, in-kind support and maintenance is also considered to be income. So this is when someone else provides shelter for that individual with disabilities. You may see on different resources, it's when someone provides food and shelter. That rule did change as of September of last year. So it's when someone else is providing shelter for them. For example, they're living in your home after you turn 18. There is an automatic 1/3 reduction in the amount of SSI that they receive. But there's ways around this, and I'm not going to go into this in too much depth, but they can pay rent to you, they can pay for their share and portion of different expenses, or it can be run through an ABLE account. And we'll talk about ABLE accounts way at the end of this presentation, but there are ways to avoid this 1/3 reduction. Now, resources, you have to have less than $2,000 in countable resources. What is not counted is one home, a car, personal items, and 529 education accounts. Everything else is counted against them for the Medicaid and Social Security eligibility requirements. So this includes bank accounts, uniform transfer to minor accounts after age 21, different investments, and other real estate outside of one home. Next slide, please. Another potential program that they may be eligible for happens after a parent dies or they start taking their own Social Security retirement. If that child was disabled prior to age 22, they may be eligible for something called the Disabled Adult Child Benefit, where they receive half of their parent's Social Security check. After being on this program for 2 years, they may also be eligible for Medicare, and they can get Medicaid and Medicare as long as they meet all of the other requirements. Next slide, please. Now, just to touch on Medicaid waiver programs, I know Allison did a great job talking about all of this. With these Medicaid programs, there's a lot of different programs available in Texas. They all have different requirements. The biggest takeaway that I want you to see from this presentation is if your child is not on Medicaid waiver waitlist at this time, you need to do research into looking into what programs your child may need in the future and getting them on that list because of the 17 to 20 year wait list. We want to have that happen now instead of in the future when they might need those services. Next slide. Now, these are other programs that are not needs-based, SSDI or Medicare. They have all different requirements. It's not based on the less than $2,000. Again, I refer you to the other presentations where they just talk about this. Next slide, please. So what a special needs trust is so good at is making sure that your child has enough resources for them beyond what government benefits provide for them. $967 is not a lot of money per month for them for anything that they might need. So the government benefits are insufficient for them. We want to make sure that they're able to have those additional resources. And a lot of parents want to leave money to their child with disabilities, but they want to avoid losing benefits because they're leaving so much money to them. Next slide, please. Now, a properly drafted special needs trust is not a countable resource. So we talked about how a bank, a car, and 529 education accounts, they are not counted against you. If a special needs trust has the proper provisions in it and it's properly distributed out, which we'll talk about here in a little bit, then it is not a countable resource. The goal of this trust is to supplement government benefits, not replace them, not supplant them. So this means that whenever we're talking about distributions, it needs to be things that government benefits do not provide for them. Distributions are also not considered to be income to the child if you do it correctly and you meet all the requirements for Social Security. Because it is not accountable, or it is a countable resource, excuse me, let me back up. It is not a countable resource and it's not income to the child. It will not impact their government benefits. Next slide, please. Now, benefits are not the only reason for a special needs trust. This is a lot of the reason why families will initially set up a special needs trust. There's a lot of other benefits that can be for your family, even if you're having trouble qualifying for those government benefits. One of the really great things is it provides flexibility for changed circumstances. So say that your child is unable to work at this time, in the future they're able to work, they're not going to qualify for government benefits. It can operate as a typical trust. And the trustee can make distributions for their health, education, maintenance, and support. So it still provides a backup cushion for them, but it won't necessarily be for government benefit purposes. So with that, the big restriction on these types of trusts is they will not be able to be their own trustee. So in the future, even if they are able to have those changed circumstances, they're able to work, they will not be able to be their own trustee. The trust also manages all the assets and distributions for the child. So think about all the bills that need to be paid, paying off an apartment, things like that. The trust handles all of that, not your child. And it also gives additional asset protection and advocacy protection for them. The way it does that is someone else is in control of your child's money. So it provides an extra layer of support for them. Someone's not trying to take advantage of them. Next slide, please. Now there's two types of special needs trusts. There is a first party and a third party. A first party special needs trust is created with the individual with disabilities' own money. And this can be from a variety of different sources. This can be from an inheritance outright, from child support, or their own savings from working. The thing with a first party trust, because it is created with that individual's own money, after that individual passes away, any money in the first party trust is owed back to Medicaid. So it doesn't happen until after they pass away, but any money left over in that trust, they go back to pay Medicaid for anything during their lifetime, and then it will go to any other beneficiaries if there's money left over.
I just wanted to mention that because we have a lot of people that attend from out of state and we serve all across the United States, Texas specifically has a Medicaid payback provision. Not all states have a Medicaid payback provision. And so sometimes we get the question, and that Medicaid payback provision is applicable to the first party special needs trust and the 529A ABLE accounts, which are also an exempt asset. And that is applicable in Texas. So sometimes people ask me if I get my special needs trust in a different state or my ABLE account in a different state that does not have a Medicaid payback, then do I avoid that? And the answer is no, because it depends on what state you are the resident in. So I just wanted to mention that because it is not applicable, that Medicaid payback is definitely not applicable in all states.
All right. Now, with a third party special needs trust, it's a little bit different. When you've heard of a special needs trust before, they're probably referring to this type of trust. So a third party special needs trust is created with someone else's own money. This can be anyone other than the individual with disabilities. Most of the time, it's parents, siblings, grandparents that are funding this trust. The beneficial thing with this type of trust is there is no Medicaid payback because it's created with someone else's own money. Whenever you're creating your own estate plan and leaving money to your child with disabilities, this is the type of trust we're talking about. It's the third party because you're leaving the money to the child with disabilities, it's not considered to be their own money. I mentioned with an inheritance in the first slide about first party trusts. That type of inheritance is if you don't set up estate planning documents and they receive it because you didn't ever set up a will or it's left to their name outright, it's considered to be their own asset, and so we have to do a first party trust. There's two different types. Most of the time, if you're doing your planning in advance, we're doing to do a third party trust. Now,
We have a few questions. If you don't mind, I'm going to kind of just go through so we stay ahead of those. What are good tax practices for special needs trust? How can we maximize use of trust spending to mitigate taxes and fees? And what I would say on that is we have done webinars. We have specifically partnered with two different CPAs that are specifically nuanced on taxation and special needs trust, both of them. have special needs loved ones themselves. They're very much nuanced on that. And it is true that if you're not distributing income from a special needs trust, that it is taxed at a high tax rate. I think it's 37%. It's really high. But there are, ways of distributing things so that way you're not exercising such high tax rates. Another person says, let's see, how long is a power of attorney valid? And can an out-of-state caregiver be named in a power of attorney and use it?
Okay, so it depends on what the language is in your specific power of attorney. I'll answer from what the general form is and what general practice is in Texas. So generally, we have the power of attorney set up where it's indefinite, meaning it can be valid forever. You can have a line on the power of attorney that says when it ends, but most attorneys will not have you put anything on there. As far as an out-of-state caregiver, there can be someone else named on the power of attorney used for that. And I'm assuming that you're talking about your power of attorney. There's also powers of attorney that are less restrictive alternatives as part of guardianship, and that's a whole separate topic. They could also be used from someone out of state, but they're different. There's more nuances there.
Okay, then we have, is designating your disabled child as a beneficiary for your federal annuity a good idea? Should it all go into a special needs trust to avoid losing benefits? And I probably say this every webinar we've ever done. It is never a good idea to name your disabled loved one as a beneficiary directly on anything that you have. And in the example of an annuity, it just depends on what program you're in, state, federal, military pension, what have you. The military pensions did pass a law back in 2015 that you can leave that annuity to a first party special needs trust. It didn't used to be that way. So you'll have to check with your administrator to see if you can leave it to a first party special needs trust. But we would not name that person outright. And so what I say on this, because sometimes people get nervous as soon as we say this, Rachel, because they think, well, I have my spouse as the beneficiary and then I divided everything equally if I die and my spouse is dead and gone. And if you've done that, you're not alone. A lot of people have done that. And it's an easy, quick form. You can do a change of beneficiary. It is free. You'll have to request the form. And of course, to be able to leave it to a special needs trust, you have to have a special needs trust set up, or provisions at least for that special needs trust. But if you're taking notes today, what I would write down is check all of my beneficiaries: life insurance, with work, outside of work, annuities, stocks, bonds, mutual funds, bank accounts, anything that could be left to somebody else. Check your beneficiaries. You have a primary beneficiary, and then there's a word that they use, and it's called contingent. Contingent is the secondary beneficiary. This is who gets it if your primary beneficiary is already deceased when you pass away. So it would be a good idea to check on those things. So then we have, if one parent does a special needs trust and the other parent is not willing to do so in divorce, a parent situation, what will happen with the inheritance coming from the parent without a trust? Let's talk about that.
Yeah, there's some different options, and that's something you're gonna have to talk to an attorney about whenever that situation occurs. The two biggest options that I see is if there's already a third-party trust established, there's a process that we can go through to modify any will that's created or any trust that's created by that other parent that doesn't have a special needs trust, to modify it to go to a third party trust that's created. If they don't have any estate planning documents whatsoever, that's not an option. We can't do that. And so we'd have to have it go into a first party trust. It can be fixed. Usually in those situations, it's not ideal. And it's not ideal if it's not going to a third party trust in the beginning, because we have to go in to modify with the court. There's a law that particularly says that we can modify to make sure someone qualifies for government benefits, but it's additional legal expense that you didn't need to do if you planned in the future, or excuse me, in the past. So you want to make sure you have that set up, because there's only so much we can do after you pass away.
And then in divorce situations, I'm completely clear on this. You can't help what the other person does, but you can help what you do. And so in some cases we see divorced people that have one special needs trust. They trust each other. It's the quote unquote good divorce. It's fine. There can be as many special needs trusts as you want. Okay. So if dad wants a special needs trust and mom wants their own because they want to be in control of it, that is completely fine. And then, sometimes it's a lack of understanding. Sometimes it's just digging the heels in a divorce situation. And I understand that. But a lot of times when the other parent understands the right way and the wrong way to go about doing it, they sometimes have a way of coming around. But there is fixes for it. So don't stress on the things that you can't control. Just focus on what you can control, and it'll be okay. What happens to the ABLE account when my son dies? If you live in the state of Texas, there is a Medicaid payback on the ABLE account, and you can see what their complicated calculations on how they calculate the Medicaid payback. It's online, and I always tell people it's just clear as mud. But, there's limits on what can be in the ABLE account. It's not like there's going to be millions of dollars in an ABLE account. Some people use an ABLE account as a savings to spend account, and there's never a lot of money in there. Some people max fund it every year because they know that they're going to pay for housing out of it, and they're going to spend it down each year. So we have some different strategies for that. Okay, income tax. Okay, she got the income tax rates. Will you provide us a list of lawyers who do special needs trusts? We absolutely do do that for sure. Then you need to also talk to your relatives about their beneficiaries, and that is exactly right. I say this all the time. Grandma and grandpa, aunts and uncles that might have your special needs loved one listed in their will, their advisor is not nuanced in special needs, and they simply just go in and say, I want to leave this money to my grandson. He has autism. And they say, great, what's his name? And that's how quick and accidentally your child's name is named directly as a beneficiary as opposed to the special needs trust for said person. So that is a really, really great point. Thanks for putting that out there. Do you have any reporting to the state regarding the third party trust? If so, how does that process work?
Okay, so the third party trust and first party trust, they both have to be reported to Social Security, but only after the trust is funded. So generally in Texas, we usually fund it with about $10 to create it. You can use it on beneficiary designations. That's not necessarily what I'm talking about. I'm talking about a large sum of money going into that trust. You need to either, if they're currently receiving government benefits, report that trust document within 10 days of whenever you fund it, or if they are not currently receiving government benefits, then it needs to be reported when you apply for government benefits. So if that is a situation that's coming up, you're potentially funding the trust, please talk to a special needs trust attorney about that, because there's some things that we have to fit in that timeline. And so we need to make sure we're getting all that things done right now.
Okay, and then the Medicaid payback, will it come from both the ABLE account and the first party special needs trust? And the answer is it can. It depends on what is owed, and they have this calculation based off of what they've paid out for the individual, and so it would be different for everyone. But you are correct that both of those accounts, the first party special needs trust and the ABLE accounts, do have a Medicaid payback. So one person said, what is an ABLE account? We have entire presentations on what an ABLE account is. You probably have some slides in here, but it's under the tax code 529A, and it is an account where a person can have money outside of that $2,000 limit that Rachel was talking about earlier, and it won't be counted against them for SSI and Medicaid purposes. So she'll touch on that. And then there is an entire presentation on the Consolidated Planning Group YouTube channel on that. And while we're on questions, and then we're just going to move on, we'll be through our questions. Can money from the monthly RSDI or survivor benefit check be transferred to a special needs trust?
I would generally say no. We want to keep that separate.
So, and what I would say on that, I agree, generally no. But again, there's two different types of special needs trust, the first party and the third party. So it's the person's money. So it definitely can't go to a third party special needs trust. I've seen some people where they might move it to a first party, but then again, there would be a Medicaid payback, but money from SSI, SSDI, and survivor benefits could go to an ABLE account, not directly, but indirectly. So if you wanted to put money that you received from those programs, once you received it into an ABLE account, you could, but again, the ABLE account does have the Medicaid payback. Okay, couple of other things I just want to hit on, Rachel, really quick. If a non-working disabled adult passes away and the adult would be entitled to SSDI equal to 75% of the parent's full retirement Social Security, the monthly SSDI is $3,500 per month. When planning, is it true that the disabled person cannot make over 2901 in SSDI per month and still maintain their Medicaid waiver? If so, how do you mitigate that? So I want to talk about that for just a second, Rachel. So what this person is referring to is that income limit for Medicaid waivers is 300% of SSI. So for this year, it is 2901, 300% of SSI. However, if they're not working and they're over that 300% of SSI due to survivor benefits or SSDI, or other public benefits, they will get to maintain their waiver. So they're talking about going over that 2901 with working and benefits. But again, if the benefits put them over and benefits alone, they're going to get to keep their waiver. So you're not going to have to worry about that. There are protections under the law to prevent a person from losing their waiver as a result of a death of a parent. Okay, here's a good one, and I know you and Trusty talk about this all the time, so I'm batting this one to you, Rachel. After the Secure Act, is it best to direct the parents' retirement accounts to the Special Needs Trust, or is there another way to direct the benefit of the disabled child, since the yearly RMD for the retirement accounts would be taxed at the Special Needs Trust very high tax rate? There is no sibling.
Okay, this is a great question. So I don't have slides on this because it's a more nuanced topic, but I think that's really important to talk about. So generally, with all the changes with the Secure Act, required minimum distributions for an individual without disabilities is over a 10-year period. For someone that is a disabled beneficiary and they have a disability determination, it can be over their lifetime. What we recommend is that it goes to that beneficiary designation still goes to their trust, but you have to have the proper language in your trust that says it can be going to that trust and still take advantage of that lifetime stretch. My background recommendation for you is yes, we want it to go to that special needs trust. However, you need to make sure that that language is in your trust. So if your trust has not been updated since 2017, 2020, you need to see a special needs trust attorney about getting this language into your special needs trust to make sure everything is going to be maximized for your child with disabilities. All right, so I think that's that. We're going to go ahead and go to the slides again. Now, how does money get into the special needs trust? We've been talking a little bit about all of this. It comes from a variety of different sources. The main ones are wills, life insurance, retirement accounts, gifts, and child support. So you'll see on the next slide, they all come together. All of these are compiled together going into the trust. I know we talked about beneficiary designations a little bit. I want to let you know, and you can go to the next slide. Thank you. The beneficiary designations, those go outside of your will. They supersede what your will says. So you want to make sure that even if you have your will saying everything goes to your special needs trust, you have to make sure you're not naming that child with disabilities outright because it's going to supersede your will. But anything that's left to your child's special needs trust, it's going to go into that trust and be used for their benefit. Next slide, please. So the next topic is child support. So child support's very unique. In Texas, after age 18, child support can continue to be ordered for the lifetime of that child with disabilities. So it's an exception under Texas law. After age 18, child support will count as income against that child. So if they have a large amount of child support, it will result in a loss of SSI and Medicaid. In order to not have those loss of government benefits, the divorce decree itself must order that child support is paid into a special needs trust. And that special needs trust, it's not going to be a third party, it's going to be a first party because it's that child's income. So if you are going through a divorce, if you're currently going to receive child support and your child's going to be over 18, I recommend talking to an attorney about this because we want to make sure that all those funds do not cause a loss in government benefits. Next slide, please. So we have all the money in the trust, everything's created. Now we're in the phase where all the money's there. How do we spend that money for that child with disabilities? So for distributions, the Social Security does not like whenever you use cash or debit cards on the trust. And it can't be anything that's paid for by government benefits. So no cash, no debit cards, nothing paid for by government benefits. What can we do? On the next slide, it talks about the ways that we can do all these distributions.
I have a question about the debit cards. So the trustee, I mean, I know we can't give a debit card to the individual with a disability. Is the trustee allowed to pay for things on a debit card on behalf of the person with a disability, or is that frowned upon?
I believe it's frowned upon. We prefer that it's a credit card that's in the trustee's name if they're going to do that.
Okay, thank you.
All right. So on the next slide, oh, this is permissible distributions. So the distributions can be made for anything not provided for by government benefits. So they can be personal care, can be social, recreational activities, entertainment, education, medical expenses not covered by Medicaid, almost anything that you can think of that the government benefits don't provide for. If the trust can afford it, they can use it for this. So an example I like to give, you say that someone really loves going to Texas Rangers games. That's their favorite sports. They just loved going to those games. The trust can pay for those tickets for them to go to Texas Rangers games if that's important and there's enough money in that trust. Next slide, please. So how do we make those distributions if we can't use cash, we can't use debit cards? The trustee can pay the expenses directly to the third party. And how they can do that is either by check or they can have a credit card themselves. The trustee would pay off this card every single month, and then it can be used however they need to do it. Another potential option is a TrueLink credit card. So this is essentially a prepaid credit card that can be given to the beneficiary. It can also be used by the trustee, but it's usually used by the beneficiary. And the trustee sets limits on where and how much money goes into that card, and then where the card can actually be used. So this allows them to control all the expenditures so it's not going to be impacting their government benefits.
The other thing about TrueLink, we've done a couple of webinars with the TrueLink debit card. It is an awesome account. And the other thing is a parent can set up limits. They can set up, like, you can't swipe this, you can't pay for something after 10 o'clock. You could block various places that they can't spend money at and various things. So it's a really good one. And we do have a webinar on that on our YouTube channel. So do check that out. And it's kind of a way to have them have some autonomy, have some, something in their hands that they could swipe and be confident about that, but within limits. Because if they are not good with money or they don't have any concept of money, it's with limits. So we are fans of that. One person says, if we already are divorced for 10 years, twins will be 18 next year, can we revisit our divorce and send child support to a first party special needs trust?
Yes, that's a potential option. So that's a divorce modification. I have done one of those fairly recently for child support purposes. The thing to consider there is how good are we're talking about the relationship between the two people that were divorced. Are you both going to agree, or is it going to reopen other issues? A lot of my special needs parents will sometimes hold off, and then when there's a modification about the amount of the child support, will bring up that it needs to be in a first party trust. So that's something that you can talk to your family law attorney about. what the best option is for you and your family, depending on that situation. But yes, the modification can occur to make sure it goes to a first party trust.
And then, so whenever, the other thing that I wanted to mention is that that being redirected to a first party special needs trust is not a DIY project. You do need a court order. So some people think if I just hire you and I get a first party special needs trust, then I can just go down to the bank and I can open up a first party special needs trust bank account and I can just change that bank account on my own. And you really got to have a court order for that. Is that correct? Is that still correct in Texas?
That is correct. And think about it this way. We talked about reporting a little bit ago. Whenever you report this trust to Social Security and to Medicaid, you're going to require, they're going to want a copy of the trust, a copy of the divorce decree. They're going to want all that paperwork. So you need to make sure it's done the right way. And most of these situations, we're working with a family law attorney and a special needs attorney getting everything set up for you. All right. Now, another question is who's going to be my trustee? So trustee duties generally are to invest the assets properly, understand how distributions affect government benefits, distribute for the child's care, keep detailed financial records, and file a tax return if a tax return is needed. Next slide, please. Now, a lot of people have not experienced, they haven't done that type of task before. Some people have, but say you don't have anyone in your life that has done that before. What are the qualities you should look for? You should look for someone that's very reliable, that has a lot of integrity, and then they have the ability and they want to learn how to implement the special needs trust rules. It's really important that they're very knowledgeable about how this works. Some people have a family member or a friend that's going to be that individual, maybe a child. We can talk through different situations on why that may or not, maybe or may not be a good idea. But it could be a family member, could be a friend. Some people don't have that individual in their life. There are different corporate options. One potential option would be having a corporate trustee from a bank. There's also something called the ARC Pooled Trust, which is another potential option where the ARC of Texas manages that trust for you. So there's some options out there, even if you don't have family support.
So one person says, do special needs trusts affect the FAFSA for college? And what I have seen, and you may have updated information, but what I've seen when I did this with my child, I mean, if it's not funded, I mean, it would be reported, but it's not going to count against you if it's not funded. But what I've seen is it depends. And every college is a little bit different. There's technically, they could all count it, technically. But what I've seen is that there are some schools, if you ask the financial aid office, they may have policies school specific that they may not count it against that person. So I think it's wise to check with schools. Do you want to comment on that, or do you have any update to that?
I don't have any other update to that. I mean, these kind of things are very specific to the school, so it just depends on where you're going.
Okay, thank you.
All right, now what happens if you don't have a special needs trust? We talked a little bit about this, but let's go through some potential ideas that I hear a lot when people say, oh, I don't need a special needs trust, I have this. So here's the things that I hear most commonly, and here's the outcomes that I see. So one option is to not leave an inheritance at all to your child with special needs. I strongly, strongly discourage this. If you do this, they will only be left with any government benefits they have. We're talking about $967 per month, whatever amount SSI is, and whatever medical care program they have. I mean, it's not a lot for them to live on. Strongly, strongly discourage it. One option is, well, I don't need to have a special needs trust set up. It can just be inherited outright. Yes, that can be done. As a remedy, we have to put it in a first party trust. So it's not ideal. And the big thing that happens with this is that that first party trust, it is not going to your other children, your other family members. You are losing all that money because they're receiving Medicaid. Another thing that we sometimes see is leaving assets to other family members. We cannot guarantee that your child, if say you have two children, one with disabilities, one with not, you leave everything to the child without disabilities. You cannot guarantee that they're going to spend that money on your child with disabilities. Even if it is the best sibling in the world, You cannot control what's going to happen to that money, what situation is going to happen there. Another potential thing that could happen is they will pass away and not leave the money to their child with disabilities. It goes to their spouse or to their children. So I strongly discourage it. The best option is to have it go to your child's special needs trust, and you guarantee that that money is being used for them.
I couldn't agree more with you on this, Rachel. It is a big deal. People die, people get divorced, stuff happens. And so even if the siblings are fantastic, which I'm sure they are, it's when stuff happens and then stuff happened to that person and they didn't have a will and it went to probate and it's a mess. There's so many things that can happen. So just please, hear her on this. It's a really big deal. And if you've thought about doing this before, certainly you're not alone. But we just wanted to share really what the shortcomings are with that idea. Because we're not thinking about that. Again, when everybody's of sound mind and health and body and things are good, we don't think about the things that could happen in the future. So, one person asked if there's a recording. Everything's being recorded. Everybody's going to get a copy of today's slides and they'll get that by email. Let's see what else we have here. If one wants to leave a house to a child, should that go in a special needs trust?
It can. A lot of people will, if say you have multiple children, they'll split the proceeds for that house, or you can say that the house goes to a particular child in their special needs trust. It's an option. We can definitely do that.
And some people do put them inside the special needs trust on purpose because the special needs trust would have protections in place to protect the individual with a disability from quote unquote being hoodooed out of the house, right? Because there would be a trustee, and ideally a trust protector and other things like that. So there are things that you can definitely do there. And remember what Rachel said at the beginning, for SSI, Medicaid purposes, you can have one house of any value. You can have one car of any value, and it's not going to count against them for that $2,000 number that she was talking about earlier.
All right. Now, what else do you need to have set up? I strongly recommend that any adult has a will. You want to make sure that you're designating where your property goes after you pass away. But if you have a special needs trust set up, you also need to update your will document to say that it goes to your child in their special needs trust, not just outright. You also want to designate guardians for your child with disabilities. So whether they are under guardianship themselves, they could potentially need a guardian, or if you have minor children, you want to designate who's going to be taking care of them after you pass away. Again, we talked about this. Beneficiary designations are very important. We want to make sure that it's consistent with your estate plan. And I recommend everyone takes a look at these at least every year or two, just to make sure, even if nothing has changed, that it's exactly what you want. Coordinate with other family members. One of the things that we do in our office once we draft a trust is we call it a donor letter. We have a letter that we're going to give you that has all the information of the trust and how that needs to be put in other people's estate planning documents. I would have that conversation coming up at different holiday events saying, you need to talk about this. If you've ever considered leaving money to my child, this is how you have to do it. You also want to make sure you have powers of attorney set up for the parents in case you become incapacitated. In all, a special needs trust is wonderful. It's going to help your child with disabilities, but we have to make sure it's funded, and we have to make sure you're protected from other things as well in life circumstances. Next slide, please. All right, let's briefly talk about ABLE accounts. We talked a little bit about this before, but an ABLE account can hold up to $100,000 without impacting government benefits. You can contribute up to $19,000 per year into that account. Please note that does change, it index with inflation. That's just the amount for this year. In order to use this account, you have to be disabled or used for disability services. And there's a Medicaid payback provision. So just like the first party trust, there is Medicaid payback for ABLE accounts. They have to be established for a person that was disabled or blind before age 26. Next year, this is changing and it's going to be before age 46. So that is changing a little bit. For funding this trust, the amount is $19,000 per year. There's up to $100,000 exempt for SSI purposes, Then after you reach $100,000, it stops SSI, but you can still have Medicaid, and it's up to the 529 education limit. In Texas, that's $500,000 if it's just Medicaid only. Next slide, please. So you can use this for education, housing, health and wellness, legal support, personal support, legal fees. The big one for this is housing. So this is something that a lot of families use in conjunction with a special needs trust. And I'm going to talk about that in just a minute, but let's go to the next slide. So an ABLE account, and it operates with SSI. Interest is not income to the beneficiary, even if it's for food and shelters. That's a difference between the special needs trust and the ABLE account. Something to note, you will have to provide records to the Social Security Administration of anything that's used out of this ABLE account. Next slide, please. Okay. So, and I think we might have skipped this slide, but the individual with disabilities, they can, I'll go back to that in a second. Okay, so there's a Medicaid payback provision. So this Medicaid payback provision, unlike the first party trust, which is for their entire lifetime, once you create the ABLE account, that's when Medicaid payback provision starts. So there will be Medicaid payback. The wonderful thing about a third party trust is there is no Medicaid payback. With this account, you can roll over a 529 education account into an ABLE account if they're the same beneficiary. So this is something that's really helpful. If you have a 529 education account that's for your child with disabilities, you might not be able to use it. You can roll it over into the ABLE account. Next slide, please. So when should I use this account instead of a special needs trust or with a special needs trust? So, and if the individual is saving their own earnings from working or from different things like their government benefits, you can put that into this ABLE account, and it can be over the $2,000 threshold with this account and still not be disqualified from government benefits. Small gifts or inheritances can be put into this trust. Again, it has to be underneath that $19,000 amount because it's $19,000 per year. So you need to keep an eye on that. And you can use that 529 rollover to ABLE account if it's the same beneficiary. Most of my clients that have an ABLE account also use this to pay rent. So you can use it in conjunction with the special needs trust. They make a distribution from the S&T to the ABLE account, use the ABLE account to pay rent, and then they're not disqualified from government benefits.
Rachel, some people think that if your loved one with a disability is working and you have their paycheck direct deposited into an ABLE account, some ABLE accounts allow that, most don't, but some of them do. They think that that income will not be counted against them for SSI purposes, and that is simply not true. While some do allow direct deposit of earnings directly to an ABLE account, those earnings are still reportable and still counted for SSI purposes. So I just wanted to mention that because there is sometimes some confusion on that.
Yeah, thank you. Okay, the last thing I want to talk about is first, when do we do all these planning? So it's not related to guardianship at all. So you may have done this process around guardianship or have been thinking about it because you're also doing guardianship. It's not related to that whatsoever. You can do this whenever. You want to do it before you become disabled yourself or before you pass away. We don't know when that's going to happen. So when I recommend to do this is whenever you are ready to have the conversations with an attorney about all these things. They can be difficult conversations. You want to make sure that this is all set up and you're doing all of this. The results of wise planning, getting all this set up, is that we have a financial team, or we have a financial plan in place. We have a support team in place. We know who's going to be taking care of your children. We give them instructions for their care. We're making sure that they're retaining eligibility for government benefits. And ultimately, the goal for all of this is we want to make sure that your child with disabilities has the most fulfilling life possible, both during their lifetime or during your lifetime and after you pass away.
Oops,
All right.
that went crazy. We have a couple of other questions, and one question was, can you give us a general idea? Now, I know for sure, and I know you know, is all law firms are a little bit different on what they charge. Can you give a person a range on what they could expect to pay to set up a special needs trust?
Yeah, so generally, at least at our firm, a special needs trust is about $5,000 to set up. If we're doing estate planning, that would be different. It would be an addition to that. If you're just doing estate planning and you're doing the special needs trust, we give you a discount on the actual estate planning part. And so it depends on if you're married or if you're single, but you're welcome to call into our office and we'll give you a quote depending on your situation. I would say, we understand it's a lot of money. It's something that you should save up for, but probably around $5,000 or so. Some people charge more than that, though.
Okay, and then you guys offer consultations, or how does that work?
Yeah, so our process, we start with a questionnaire. So we're going to get some information for you. Then once we have that questionnaire, we're going to assign you to an attorney. And then we do a consultation either by Zoom or in person. For us, if you decide not to proceed with our firm, we do charge you at our hourly rate for that consultation. However, if you decide to proceed with our firm, it's all included in the flat fee that we give you.
Okay, perfect. Few other questions. The Medicaid payback we covered in detail, and you'll get a copy of the slides and a link to the recording. Can an individual with a disability and minimum SSI benefits pay rent from the SSI and ABLE accounts as part of the fair share to maximize benefits? You absolutely can pay rent out of the SSI benefits or the ABLE account. And then when you have that rent agreement set up, you're going to want to send that into the Social Security Administration so they raise the SSI amount up to the 967. 967 is the full SSI amount. If you're getting 600 and something, it's being reduced by 1/3. If the individual's not working, it's being reduced by 1/3. And that tells Rachel and I that you need to have a rent agreement in place. We help set up ABLE accounts. There are ABLE accounts all across the United States, not a specific agency. There is a Texas ABLE account. That is not the one that we go with. So we actually help people set up ABLE accounts and educate people further on ABLE accounts all of the time. Can a 529 account be transferred to a special needs trust or ABLE account? A 529C can be transferred to a 529A, but it is going to be subject to those limits that she talked about each year. They go up a little each year, but this year is $19,000. So if we have a 529C, we know the child with a disability is not going to go to college, or at least we don't think they're going to. We can start transferring that to the 529A, and the 529 ABLE will have less restrictions on what you could spend the money on for the benefit of said child. Furthermore, if that child goes to college later, you could still pay for college out of the ABLE account without a penalty. So that is definitely a thing. Let's see here. I'm trying to see if we missed anything else. We talked about the cost of the special needs trust. I think that is, let me see. ABLE distributions, do you have to report an ABLE account on your tax return? You don't. They'll send you a little tax form for the ones that we go with, but it's not a reportable. There's no taxes unless you take a distribution from an ABLE account that was not for achieving a better life for an individual with a disability. Then it would be taxed and penalized, and then it would go on your tax return. So these are things to keep on your special needs planning radar. Future care cost estimate, waivers, Medicaid waivers, SSI, SSDI. We talked about a lot of this stuff today. Special needs trust, guardianship, alternative to guardianship. We didn't go into that today. We have entire webinars on that topic, and we do suggest that you check those out if you're coming around the bend to age 18 and you're wondering the difference between guardianship, partial guardianship, supported decision-making agreement, power of attorney. Well, you'll want to check those out. So you're going to get a link today to the recording and a copy of today's slides. It'll have a link for our upcoming webinars that you can register for the ones that might make sense for you. We do work on a collaborative team here at CPG. We stand ready to support you on your planning journey. If you had additional questions that didn't get answered, feel free to schedule your free personalized consultation where we can go deeper with you. Yes, we do make referrals for qualified attorneys. for planning for special needs trust and guardianship and things like that, as well as the CPAs. Happy to partner with you on that. So Rachel, it's certainly been my pleasure to be back here with you today. You always provide such great information. So do check in with Rachel and the Weeks Law Firm and set up your consultation. Do check those beneficiaries. If you were taking notes today, we said not to name your loved one with a disability directly as a beneficiary on anything that you have, including grandparents and stuff like that. So you do want to double check those beneficiaries. So thank you so much, everyone, for being here. Thank you, Rachel, and we will look forward to connecting with you again soon.
Wonderful. Thank you so much.
Thank you. Bye now.